Rule 25, Section 1. Interrogatories to parties, service thereof. Upon ex parte motion, any party desiring to elicit material and relevant facts from any adverse parties shall file and serve upon the latter written interrogatories to be answered by the party served, or if the party served is a public or private corporation or a partnership or association, by any officer thereof competent to testify in its behalf.
A purpose of this rule was obtained admissions and thus limit subjects of controversy at trial and avoid unnecessary testimony and waste of time in preparation. It is also intended that the rule should provide ample facilities for discovery of facts before trial so that surprise at the trial and possible miscarriage of justice might be avoided.
Rule 25, Section 2. Answer to interrogatories. The interrogatories shall be answered fully in writing, and shall be signed and sworn to by the person making them. The party upon whom the interrogatories have been served shall file and serve a copy of the answers on the party submitting the interrogatories within 15 calendar days after service thereof, unless the court, on motion and for good cause shown, extends or shortens the time.
To reiterate, answers to interrogatories shall be full in writing, signed and sworn to by the person making them, filed and served on the party submitting the interrogatories within 15 calendar days after service thereof, unless the court extends or shortens the time.
Rule 25, Section 3. Objections to interrogatories. Objections to any interrogatories may be presented to the court within 10 calendar days after service thereof, with notice as in case of a motion, and answers shall be deferred until the objections are resolved, which shall be at as early a time as is practicable.
Under Section 3, interrogatories may cover as broad a field of inquiry as when the interrogated party is called as a witness to testify orally at a trial. Under this rule, the disclosure sought is not limited to material or ultimate facts, but extends to all facts, whether ultimate or evidentiary, which are relevant except matters which are privileged. For example, the information that is part of the work product of a lawyer is privileged from deposition discovery rules.
Rule 25, Section 4. Number of interrogatories. No party may, without leave of court, serve more than one set of interrogatories to be answered by the same party.
Section 4 of Rule 25 discusses the number of interrogatories that a party may serve. It says that no party may, without leave of court, serve more than one set of interrogatories to be answered by the same party. A leave of court is a legal term used to describe asking the court's permission to allow something that the court doesn't normally allow according to its rules and procedures. Also, this means that the party may only serve one set of interrogatories unless the court allows for more. So once again, no party may, without leave of court, serve more than one set of interrogatories to be answered by the same party. This is what is discussed as numbers of interrogatories as provided for in Rule 25, Section 4 of the Rules of Court.
Rule 25, Section 5. Scope and use of interrogatories. Interrogatories may relate to any matters that can be inquired into under Section 2 of Rule 23, and the answers may be used for the same purposes provided in Section 4 of the same rule.
Inasmuch as the answers to interrogatories may be used for the same purposes of depositions, they may also be the basis of a summary judgment under Rule 35.
Rule 25, Section 6. Effect of failure to serve written interrogatories. Unless thereafter allowed by the court for good cause shown and to prevent a failure of justice, a party not served with written interrogatories may not be compelled by the adverse party to give testimony in open court, or to give a deposition pending appeal.
A party not served with written interrogatories may not be compelled by the adverse party to give testimony in open court, or to give a deposition pending appeal. In the case of Apologentia, one of the purposes of the above rule is to prevent fishing expeditions and needless delays. By requiring prior written interrogatories, the court may limit the inquiry to what is relevant, and thus prevent the calling party from straying or harassing the adverse party. The rule not only protects the adverse party from unwarranted surprises or harassment, it likewise prevents the calling party from conducting a fishing expedition or bungling its own case.
Please rise. The court is now in session. The Honorable Judge now presiding.
Everyone but the jury may be seated. Bailiff, Ms. Lisaka, please swear in the jury.
Please raise your right hand. Do you solemnly swear or affirm that you will truly listen to this case and render a true verdict and a fair sentence as to this defendant? You may be seated.
Members of the jury, your duty today will be to determine whether the plaintiff has failed to comply with the rules on discovery by never serving answers to interrogatories. Ms. Lisaka, what is today's case?
Your Honor, today's case is Santiago Uy Barreta versus Raul Arellano and Emilio B. Bayona.
Is the prosecution ready?
Yes, Your Honor.
Is the defense ready?
Yes, Your Honor. Respondent Santiago Barreta filed with the respondent court against petitioner Raul Arellano, Emilio Bayona for reconveyance and damages of a certain parcel of land located in Sorsogon. Petitioner Arellano filed a motion to dismiss on the complaint. Simultaneously, Arellano dispatched written interrogatories to which respondent had received on May 9, 1967.
I will dispatch written interrogatories to you, Barreta, and if you fail to file a responsive pleading within 5 days upon receipt, your complaint will be dismissed. Try me, Barreta. What can you say, my counsel, should I dispatch written interrogatories?
No action by the court was taken on the MTD until February 12, 1969, or 1.5 years later. The court then set the case for hearing and ordered Barreta to file an opposition on the MTD filed by Arellano. Barreta was not heard from.
And now that you failed to serve answers to the interrogatories, despite the periods previously given to you by the court, Barreta, you leave me no choice.
All right, chill. Let me ask for deferment then. The court gives another 10 days to the respondent to file any responsive pleading. Aggrieved, petitioner filed another instant dismissal in which the court finally granted. Copy of this order was served on Barreta, thus the incident seemingly ended.
You deserve it!
The war has just begun. The court denied Barreta's motion. However, to avoid his case from being terminated, Barreta again filed this time a motion for admission of amended complaint. This is not the end.
We'll see, Barreta. We will see.
Arellano moved to set aside this order, but after it was opposed by Barreta, the trial court issued an order of denial, which counsel for Arellano claims he has never received, so much so that, unaware of such denial, he filed a supplemental motion.
What? This is unfair. Your failure to serve any answer to my interrogatories was erroneous for the trial court to dismiss the action without first ordering you, Barreta, to answer my interrogatories. Waiting for your failure to do so has no merit, and neither is there merit in the claim that the sending of the interrogatories in question had not yet been given due course by the court, and leave of court is not necessary before written interrogatories may be served upon a party. That's according to Attorney Annalise.
Okay, order in the court. Let me settle this. Plaintiff in this case contributed actively to the unreasonable and unexplained delay of the preliminary incidents. His excuses in relation to the written interrogatories are flimsy and groundless. Under the rules, it is the duty of a plaintiff to always take the initiative in keeping the proceedings active and going until it is terminated. Otherwise, his case may be dismissed either upon motion of his adversary or of the court itself. Thank you, jury, for your service today. Court is adjourned.
Petitioner spouses Vicente and Leticia Alcohencia filed a complaint against the respondents Metrobank and Emmanuel Ortega before the RTC of Malolos City. After the filing of the parties' pleading and with the conclusion of pre-trial, petitioner filed a motion for issuance of subpoena duces tecum ad testificandum to require Metrobank's officers to appear and testify as the petitioner's initial witnesses.
We need the officers to testify and bring documents relative to our loan with Metrobank, as well as those covering the extrajudicial foreclosure and sale of our land in Bulacan.
Metrobank filed an opposition, arguing lack of proper notice of hearing.
Ay, hindi pwede yan. Wala nga silang binigay na proper notice of hearing eh. Di nga sila nakapag-set ng date and time. So, dapat, ineffective yung motion for issuance of subpoena. Kasi, fishing for evidence yung ginagawa nila eh.
Di yan ineffective. Nag-file na kayo ng opposition eh. So the lack of proper notice of hearing was already cured by that. The issuance of subpoena is not unreasonable and oppressive. In fact, it would also be favorable to Metrobank. Total, magpe-present na lang naman sila ng evidence. The witness will be able to prove whether we have paid our obligation in full.
The Regional Trial Court of Malolos City denied petitioner's motion for issuance of subpoena and motion for reconsideration for failure to comply with the requirements for a valid notice of hearing, and that defendant bank and its officers are adverse parties who cannot be summoned to testify unless written interrogatories are first served upon them.
Alright, tama. In the present case, the petitioners seek to call Metrobank's officers to the witness stand as their initial and main witnesses and to present documents in Metrobank's possession as part of their principal documentary evidence. This is tantamount to building their whole case from the evidence of their opponent. A burden of proof, evidence falls on petitioners, not on Metrobank. If petitioners cannot prove their claim using their own evidence, then the adverse party Metrobank may not be pressured to hang itself from its own defense. One of the purposes of the above rule is to prevent fishing expedition and needless delays. It is there to maintain order and facilitate the conduct of trials by requiring prior written interrogatories. The court may limit the inquiry to what the relevant and thus prevent the calling party from straying or harassing the adverse party.
This is a case wherein the Presidential Commission on Good Government filed for a suit for the recovery of ill-gotten wealth with damages against Edward Marcelo, in his capacity as the president of Marcelo Fiberglass Corporation, for taking advantage of his relationship with the Marcoses to obtain a preferred contract. The contract herein involved the construction of 55 units of fiberglass speedboats for the use of the Philippine Navy.
Hello there, Mr. President. Yes, please consider my services in the construction of 55 fiberglass speedboats.
Yeah, for sure. We're homies. You should be the one to make the speedboat.
Thank you.
The PCGG then filed the suit with the Sandigan Bayan, to which the latter filed a complaint on behalf of the Republic of the Philippines. This is against Marcelo in his capacity as the president of MFC. This now prompted Marcelo to submit his own pre-trial brief with written interrogatories.
But I am a mere stockholder of Marcelo Fiberglass Corporation.
The Republic of the Philippines then filed its answer to the written interrogatory submitted by Marcelo. And on the year 1997, the petitioners filed 3 separate motions for summary judgment.
I am filing this motion because there is no genuine issue of fact and there is no cause of action. Also, I have already requested to admit the truth in the matter of fact in my pre-trial brief, but the Republic of the Philippines did not reply.
MFC's motion, on the other hand, alleged that there was no genuine issue of fact and there was no cause of action, and that the Republic of the Philippines continued to refuse the written interrogatories and reply to the request for admission on certain facts set forth in its pre-trial brief. We are denying these motions of Marcelo and MFC because the answers of the Republic of the Philippines to the written interrogatories given by Marcelo and company shows the existence of genuine factual issues between the parties through the alleged favored contract mentioned in the complaint. Now, things aren't looking too good for Marcelo and MFC, as Sandigan Bayan wanted to know whether MFC was used as a conduit by Marcelo to amass ill-gotten wealth through his influence with the Marcoses. The issue, however, is whether or not the respondent Sandigan Bayan committed grave abuse of discretion amounting to lack or excess of jurisdiction in denying the motion for summary judgment of Marcelo, MFC, and the other petitioner corporations. Guys, let's not argue. First of all, the petition is impressed with merit. All that is entitled to activate or put in motion the process of discovery by interrogatories to parties under Rule 25 of the Rules of Court is simply the delivery directly to a party of a letter setting forth a list of questions with the request that they be answered individually. That is all. And serve of such a communication on the party has the effect of imposing on him the obligation of answering the questions separately and fully in writing under oath, and serving a copy of the answers on the party submitting the interrogatories.
Nagpataw, interrogatory, pagpanagpag emotion, kung party, isang punte, sa may baklaran, umirma, pinadala, wala akong nagawa.
Naaalala mo pa ba noong tayo pang dalawa? Di ko inakalang sa korte ang punta. Tinawagan pa kita, tinawag mo akong walang hiya. Law student ka pa noon, ngunit ngayon. Hey, iba na ang iyong tingin, ikaw na ang party. Nag-file ka pa ng interrogatory. Sana'y hindi nalaman, sana'y walang problema, pagkat kulang ang dala kong bala. Pangsagot, pangsagot sa illicit material.
Siguro nga ngayon, may sagot na ako. In writing pa ito, pinirmahan ko. Sana ay natanggap mo na. May 15 calendar day pa, unless extend ang court for good cause.
Ito na ang iyong ikaw na ang party, nag-file ka pa ng interrogatory. Sana hindi malaman, sana'y walang problema, pagkat kulang ang dala kong bala.
Hindi ako papayag, hindi ako natutuwa. Meron akong objection, sa'yo pinadala, hindi ko to natanggap. Hindi kailangang ibuklat pagkat hindi deserve ang interrogatory. Yeah!
Iba na ang iyong tingin, ikaw na ang party. Nag-file ka pa ng interrogatory. Sana'y hindi nalaman, sana'y walang problema, pagkat kulang ang dala kong bala. Hey, iba na ang iyong tingin, ikaw na ang party. Nag-file ka pa ng interrogatory. Sana'y hindi nalaman, sana'y walang problema, pagkat kulang ang dala kong bala.
Pangsagot, pangsagot sa illicit material.
Nasaan ka na kaya? Sana ay masaya, sana sa susunod na issue may written facts ka na.